I'm just going to give a quick talk here for Artefactual Theory of Precedent. I'm Ken Ehrenberg, co-director of the Surrey Center for Law and Philosophy and at the University of Surrey Law School. I'm just going to talk the paper. It's very short. It's very rough. It's just some preliminary thoughts about this matter for a book chapter that I'm writing. Really interested in getting any kind of feedback that you might have. I'm feeling a little bit, not lost, but just in the early stages here. I hope to have more done. Hopefully you can help me to see where to go. I'm going to talk it through, but I'm going to show it to you as I'm going to talk it. So I'm not usually one to read papers, but in this case, I feel like it's closer to what this is the most developed thoughts are on the page already. So I might say a few things as I go through. So as I'm just saying now, it's just a beginning of thoughts, an attempt to problematize the notion of precedent within an artifactual theory of law. I'm going to use my theory of my artifactual theory of law that I put in a book from 2016 called The Functions of Law. But it probably should go just as easily for most artifact theories. My theory is that law is an institutionalized abstract artifact. In the nutshell, that means that it's a genre of institutionalized abstract public artifact. Artifacts are understood using Dijkbert's framework, which makes them a subset of tools, which are in turn a subset of instruments. So instruments are anything that are used for a purpose. Tools are things that are adapted to serve that purpose, and artifacts are tools that communicate their usage to a specific audience of potential or actual users. Public artifacts, using Emmy Thomason's word there, is just artifacts that are made to be used by more people than the creator or author. Of course, once you say you're doing it to communicate, it's not clear that the author really needs to communicate to him or herself, but we'll put that aside for now. So perhaps beyond the people that the author can communicate directly. So one useful thing about artifacts is that they communicate their usage to a variety of potential users. It doesn't have to be just people that the author had in mind. To say that the artifact is abstract is simply to say that it's non-corporeal. I don't mean anything, I'm not meaning to deny anything about that, about like how it only exists over a limited time or anything like that. Some people say abstract things have to be not located in time. I'm not sure I agree with that, but in this uses of abstract, we can call it a more colloquial use. I'm not saying anything about time. One reason to say that it's abstract is just to say that laws are not identical to any instance of their recording. You could have a law, every recording of it could be destroyed. As long as it's in the minds of some of the officials, at the very least, the law continues to exist. To say that laws are institutionalized, or that they are institutionalized abstract artifacts, is simply to say that they're created within a system for altering people's rights and duties, their deontic powers, in a context specified by the institution as its ambit. So these are rights and responsibilities within the institution. It's not necessarily making claims about your wider rights or responsibilities, full stop, your moral ones. It may be doing that, especially in the law, it might be doing that. But as far as institutions go, they don't have to be thought of as background moral responsibilities any more than, let's say, that you would be committed to by having embraced the institution or become a member of it, assuming you had a choice or something like that. So you could imagine other institutions changing people's deontic powers doesn't necessarily say anything about their moral responsibilities. It could, but it doesn't have to. So that change in their rights and responsibilities is effected by specifying special statuses within the institution for objects, people, or events who are also given special statuses by some foundational constitutive rules of the institution. So most of the audience here are probably pretty familiar with this kind of Searlean picture of institutions. The role of precedent in the law could suggest a possible tension in seeing law both as an institution as an artifact. This is a problem, right? And it's this tension that I aim to dispel. Not sure the tension is fully developed, but this is where I thought to problematize the considerations here. The problem with this possible tension is that I generally think of institutions as a subset of artifacts. So it's actually a bit redundant to say that law is a genre of institutionalized abstract artifacts, because once I say it's institutionalized, I'm already implying it's an abstract artifact, but there's a utility in focusing specifically on the properties of institutions and on the properties of artifacts separately, So that redundancy is justified. We get a little bit more information by thinking about, oh, it's an institution, and a little different information by thinking, oh, it's an artifact. So that's why it's important to keep them both there. So if there's a tension in seeing law both as an institution, or at least when you think about precedent, if there's a tension in seeing law both as an institution as an artifact, that would strongly suggest either that it's neither an institution nor an artifact, or at least at least one of them is wrong, or that I'm wrong in thinking of institutions as kinds of artifacts. So I'm eager to dispel that. And I think, precedents are sort of the problem. And if I can explain how precedents can still fit in the picture, then I'm solving the problem. So artifacts clearly have histories of development and adaptation. Beth Preston calls it reproduction with variation. Artifacts are adapted and developed in response to circumstances that change, and their functions may be refined or revised over time. That suggests a freedom that is not overly constrained by a set of rules for alteration of the artifact, right? So it's important in artifact theory in general that people maybe there's an original creator of the artifact, but that users can take ownership over the artifact and change its use and refine it and improve it and things like that. It's not always going to be true, but it's something about artifacts in general. There may be norms of usage and identification that the author or creator communicates with the artifact to her intended audience, but in altering our existing artifacts and developing new ones, authors generally have a free hand, right? So when we said that artifacts are tools that communicate their usage, that implies certain kinds of norms as a result of the communication. I think of these as akin to requests. So you imagine, in general, we can create norms for each other. We can create reasons for each other by asking for favors. For example, I'm asking for your favor. Please come to my Q&A session if you're listening to this, so that you can ask me some questions and I can help me refine the paper. That gives you a reason to do that. Now, I don't actually know who's listening to this right now. So in a way, I'm creating this recording for you, whoever you may be, to give you a reason to come to the Q&A session and help me refine the paper. So I'm asking you, even though I don't know who you are, to do something for me. And that theoretically gives you a reason to do it. I mean, you may have very good reasons not to do it, but it gives you at least some reason to do it. And so this is the idea that the communication of the author of the artifact communicates two different kinds of norms. One will be a norm of usage, which is a very weak norm, which is just to say, this is a hammer, this is a chair, use it like a hammer or a chair. If you don't want to use it like a hammer, if you have a good reason for yourself for not to use it like that, like for example, you can use your hammer as a doorstop, that's fine as long as you have a reason to do so. But in general, there's a very weak norm of usage to use it in the way that, that it was intended, so to speak. There's also a norm of identification, which is a little bit more stringent. It doesn't require very much of you. It just requires that you recognize that this is a hammer. Even as you're using it as a doorstop, it still stays a hammer. So that's a norm of recognition or identification that's harder to avoid. Now, there are some circumstances in which you can avoid it, and there are other norms that govern how and when to do that, but it's harder to justify departures from the norm of identification than it is from the norm of usage. The norm of usage is very weak, although it just requires something specific, whereas the norm of identification doesn't require very much, just recognize this for what it is, but it's harder to justify a departure from it. But in altering existing artifacts and developing new ones, authors generally have a free hand. Precedent seems to be a norm that would cut against this notion that people can develop things and they have a free hand to do that, as it's a way for the law to fix its application and usage over time. If we think of a judge as being a kind of artifact user, then generally we would want to say that the norm of usage is quite weak and that she should have a free hand to use the artifact in whatever way she thinks is appropriate, which is what I just explained. But precedent purports to bind her to specific usage. So in a non-common law system, the role of precedent may be more in line with what we would expect from a system of artifacts. Prior applications of law would be simply like more like prior uses of the artifact. They would be helpful guides to current usage, but not necessarily binding in the way we think of precedent as binding in a common law system. Now, I don't know that much about non-common law systems, but I know that precedent is less binding, but it still has some force. So I think the problem is still there. It's just not as acute for non-common law systems. But in common law systems, prior applications of law are understood to be more binding than we would expect with artifacts more generally. It's not that this is necessarily a problem, because we could likely imagine some artifacts for which the norm of usage is more stringent. Items of symbolic or ritual value come to mind. But given elsewhere that I rely on the weakness of the norm of usage in the law to allow for flexibility in interpretive strategies, this is somewhat problematic. So I'll just tell you what that is very quickly here. That's just the idea that I don't think this theory, my theory of law as an institutionalized abstract artifact, puts a lot of weight on the creator. It gives the creator a certain kind of initial privilege, although it can be taken away, to set the identity of the artifact and things like that. That doesn't, I claim, make any implications about interpretive strategies for law. It doesn't mean you have to be an intentionalist when it comes to legal interpretation. And the reason for that is precisely that this norm of identification is so weak. Okay. The institutionality of law can explain the greater constraints that we see in it. Institutions constrain their members to uses of the institution in keeping with its rules for which actions or instances are considered to be bona fide. That means that, the institution sets rules, and the rules determine which applications of the institution count as real ones, so to speak, or as institutional ones, as opposed to counterfeit. So there's this notion of validity that's already coming in with institutions, which of course is very important in law. The rules of institutions generally tell us what count and what doesn't. What's the proper way to confer the status that carries deontic powers and how to deploy those powers? So the greater constraints on future decisions that precedent seems to impose, especially in common law jurisdictions, can be understood as one facet of the way the institution of law deploys its institutional rules about what counts. Just kind of explaining what I just explained. The problem is that while the norms that underlie the legal doctrines that are being applied in judicial decisions are subject to the constitutive rules that specify their validity conditions and functional uses, boy, I have to rewrite that clause, don't I? The decisions themselves are more easily understood as applications of the surface level legal rules. So the problem here is just like, okay, well, these rules that we're talking about, these seem to be the background validity rules and not the surface level rules, legal rules that we think of as being the subject of a lot of these precedents, like, what counts as, a certain kind of negligence for tort, what sorts of reliance count for a contract to be enforced, those kinds of things. To imply an overworked analogy to games, it would appear that the decisions of judges are more like moves in the game, rather than setting forth the constitutive rules by which the game is supposed to be played. If the decisions are moves in the game, then it makes sense to say that those moves are constrained by the rules of the institution, but it's harder to see those moves as imposing further constraints on future decisions, right? So once we want to say they're moves in the game, they're applications of the rule, but they're not these kinds of, validity decisions that we would think of as being the sorts of things that would have the precedential value, right? So it would suggest that precedent, if you have an artifact theory, precedent shouldn't really be binding, right? Because at least in my artifact theory, it shouldn't really be binding anyone, because everyone should have this free hand to just rework and reuse whatever they want. So it's hard to understand unless you want to just say, oh, well, there's something special about law, which is fine. But if you're trying to say it's not necessarily like just something special about law, then it would seem as though you want to have, that you want to try to figure out a way to explain the bindingness of precedent using institutionality. But when you try to do it using institutionality, you get this problem of, well, then it seems like the artifact, the precedential decisions are just like moves in the game, and they're not obviously binding on why do they bind, is the question. Okay, but here's the glimmer of the way out, which is where I really need the help. Are they really like moves in the game? Unlike moves in a board game, every judicial decision that carries precedential value is also a validity determination. This is like, when I thought of this, then I thought this could have a lot of implications. And it may actually, I started thinking, might be something that Dworkin was actually thinking about already, which scared me for a moment too. So I have a lot of thinking to do about this, but let's talk it through and then see what it means. In every case that has at least two sides to the issue at hand, The judicial determination that sets a precedent for future decisions about how to avoid running afoul of the law and how to apply it when someone is thought either publicly, privately, or tortiously they have run afoul of it. Okay, so again, another clause I need to break up. In every case, it has at least two sides to the issue. The judicial decision that sets a precedent for future decisions, right, is impliedly or explicitly stating that the losing side's argument or action is legally invalid. Okay, so this is the part that's kind of sort of mind-blowing a little bit. Every precedential, I mean, maybe the legal realists were already thinking about something like this too. Every precedentially valuable decision is not just a move in the surface level game, if you think about it. It's not just an application of law. It's not just I'm going to do this action because this is what the law requires, right? It's also impliedly an interpretation about one side's action or argument being legally valid and the other side's action or argument not being legally valid, right? It's a little bit different for cases of criminal cases where the only thing that's being determined is the guilt or innocence of the defendant. We're going to put those aside. I have a footnote where I describe that and stuff like that. In the next sentence, I say, more precisely, the decision, except where the decision is merely one of criminal guilt, which in many jurisdictions is understood as a determination of fact and not law anyway, is that the losing side's argument is not a correct application of the law and hence is not a valid move in the legal system. Hence, if the law is like a game, it's more like the game Gnomic, which Peter Suber created, another philosopher, in which players make moves in the game by making or changing the rules of the game, which of course makes the whole game analogy unhelpful because Gnomic was originally designed to model or mimic legal systems anyway, so we're not getting anything from the analogy anymore. It's not quite that the judges are changing the basic rules by making validity determinations. There are still more basic validity determinations, and I have to think about more of the implications of them trying to track each other's work here too. But in the sense that each determination purports to set forth a pattern by which future actions or arguments can be measured for legal validity, they do constitute a new pattern for decisions, which could certainly be described as a rule, right? So again, the key here, and this is, I have to develop it a lot more, is the realization that precedentially valuable decisions are validity determinations in and of themselves. And since they're validity determinations in and of themselves, in a kind of Hardian framework, it's as though every one of those is a direct application of the rule of recognition, not just an application of the rule of recognition, but in a sense, a kind of contribution to it, right? Because I mean, each official is trying to accord themselves with the rule of recognition, but also in a sense, at the same time, by fleshing it out, by applying it to a new situation. Each precedential decision does seem then to be an institutionalized abstract artifact. Each precedent is a tool that is intended by its author to perform a function and to communicate that function to an audience of users who are lay people who may find themselves in similar situations, such as an audience of users, examples, lay people who may find themselves in similar situations, lawyers who are advising clients in similar situations, and future judges who have to adjudicate similar situations. It's very much institutional as it is a decision partially about assigning a status, legally valid or not, to each side of the issue, applying pre-existing standards of validity. And those statuses carry deontic powers and responsibilities within the context of the wider institution. And that's it. That's all I have right now. I need help. I'd love to have any of your comments or questions that you think about. Anything that I have a few, I could also use a lot of any suggestions on literature to start thinking about this. I haven't done a lot of work on precedent before. I've been asked to write this on precedent and to try to think about how precedent would fit into my wider theory. So that's what I'm starting to do. And that brings me up to 20 minutes. So I think I've accomplished my goal here of finishing the video in 20 minutes, but I do hope you'll join me. Let me see, when's the Q&A session? I'm just going to look it up quickly here. I think it's on Thursday, that is a week from today, but that's Thursday the 12th. I can't remember exactly what the time is on the West Coast of the United States, but here in the UK, it would be 5:20 p.m. So hopefully you can make it. and give me some ideas about where to go from here. Thanks a lot for listening. I really appreciate it.